lordship, and here the both parties are ready to compromise the lordship. In the meantime,
Ready or really compromise?
ready to compromise your lordship.
Okay.
Kindly mention.
Do you have agreed?
Agreed, yes.
Yes, sir. What did? Item? 37. Okay. Which date you want? You tell sir which suits you, so that you will not ask for adjournment next time. Let's go. And you give it. Go.
Final item 46.
Everybody.
Senior advocate engaged in this case will not take it up.
You are senior for everyone. You can argue.
I am for the part number 2. In the matter pending before the appeals court on hearing on the section part on 13/11.
Okay, after 13/11. After
13/11. Let the matter. Mr. K. N. Tripathi is the conducting counsel in this matter. He is on his legs, my lord.
Is it the fact that the matter is to be heard by Supreme Court?
My lord, I don't have instruction, but he had instructed me to let the matter.
Which item? 40?
46. Let it come.
Unless he gets stuck, you know.
Unnecessarily.
This morning, today, you know, today you will immediately next week we will put it. Next week we just see it.
My lord, item 41.
It will make him free unnecessary. It will be and ultimately he will be
My
stuck.
lord, item 41.
Okay, next week, huh?
Item 43.
Yes.
Compromise matter may be taken up 2 weeks after that outside
What is the offense?
offense 5 proceedings and other offenses.
Online they should appear and finish it up.
So 2 weeks after.
2 weeks after.
My lord, item 41. Next took Mr.
Yes.
41 million.
41?
41 million.
Yes, sir.
Next week, any date, my lord, on behalf of Mr. Swine, he is ready.
Next week may not be possible.
It will be up.
Yes, sir. Urgent call.
I may be pardoned, my lord. Item number 4, my lord.
4, huh?
Item 4, my lord.
Yes, yes.
One the informant, my lord, authorized expired. So may I because my lord is directed for appearance of the parties because the compromise matter. May I only 2 weeks after any day, my lord.
2 weeks after, huh? 2 weeks after.
Oblige, my lord.
Yes.
Today's
Out of list, one online mentioning. Otherwise, they'll keep on speaking, you know. Then they will understand. Yes, yes.
Item
Yes,
29. Today's
Yes,
list,
sorry.
I
Item?
have 29, my lords.
Yes. What do you want?
I have received consent from the party, my lords. But I'll file my wakalat number. Let it come after vacation, my lords. The Diwali holiday.
You are for petitioner.
My lords, I have received consent from the petitioner, my lords.
But
To
you
file.
have not cured defects. See, so many defects.
My lords, I did not have power in the case. I have just received consent yesterday, my lords.
Okay, let counsel for the petitioner submits that he would be curing all the defects within a week. Leaves the matter after 1 week. Okay.
Deeply obliged.
Yeah.
Out of list matter, the matter as a dismissed for different, I have filed a petition for restoration. During the meantime, the petition has died, I have filed a substitution petition. So I claim this matter.
What is this matter? Why substitution? Nothing.
This is relating to the regulation 2 matter. Matter was dismissed in the year 2016 when I was not after, but then the matter was dismissed. Then I was
16 dismissed now.
not minor, but this is a special assignment to minors. Because of that, I have mentioned.
Least it will see on that day. Least we'll see that. Okay.
I'm pardon to make a mention, your lordship.
Yes.
Lordship, this criminal appeal of 2011, your lordship, business matter, your lordship, it's ready for final hearing. I'm praying for the matter to take a note.
It is there in the weekly list, including the weekly list. Get ready. Get ready. Okay. Get ready with your notes of submission and all, and you have to argue. If you bring senior, then I will not hear. Yes. Yes. The appeal and all, the junior should argue. All juniors should argue. And lawyers like Mr. Sharang, and they should not be allowed. Right.
For what your lordship?
All the appeal matters should be argued by juniors. You people should not be. You should argue at all.
Your lordship said we are very safe, except for here and there. So that
KVAD is very dangerous.
and we are there to correct your lordship wherever
Yes,
that way or this way.
that is always welcome. That is always welcome. Yes.
Item 52 chapter.
52?
Mobile से तो
50, item 50, full chapter.
52. After.
कितने सरकारी विषय रोजगार को आप प्रदेश
See, with that 52 notice is sufficient. I don't know if somebody will hear. 50. Okay, 50. Then neither AD nor answered notice returned to opposite person. Delivered to addressee. I'll adjourn it, but I'll keep it at the turn because if somebody appears, then I'll record his appearance. No? You are free. You are free. So I'll give the date will be given at the turn because somebody may appear. Yes. Yes.
Item 1, I may be permitted to withdraw. Item 1. Liberty to file a better application.
Liberty to. Yes. 7N? Yes.
Husband was involved in dispute. Marriage lasted only 6 months or so. Now the FIR is there, there is nothing to husband take a lawsuit with there. There is nothing. My wife has already filed a petition for divorce in the court.
I'll issue notice, let them come.
Check notes. We also take notice. Because there are some possibilities that there is
Some possibility?
for either this way or that way. It's a compromise or
No, this is, what is the stage?
we are on 41. There is no problem.
See, these are matrimonial, I'll issue notice and, Mr. Vada, I'll stay also. I'll tell you. If you aggravate, then the chance of settlement will be again affected. In a matrimonial dispute, if things are aggravated, then the chance of settlement is reduced. So it's better that
Another prayer to yours. Nahi koi agar affected dekhibe.
हाँ देख सकते हैं देख सकते हैं
he is being paid for that. Nahi koi affect. You can't prevent that. You can't prevent that.
My lord, I may be pardon, my lord.
Yes.
That I,
Okay, I am issuing notice and both the matters issue notice and Mr. Sadangi, legal counsel for the petitioner submits that the dispute is arising out of a matrimonial discord. There is a chance of settlement between the parties and the parties, the husband has already applied for divorce.
Why?
Wife has already applied for dissolution, approached the family court for dissolution of marriage. In view of the aforementioned statement, the proceeding before the where is it proceeding before the which court is this proceeding before SDG and Bhubaneswar in CT case number 1117 of 2024 is state till state of hearing selection to mediation.
Not now, let them appear.
Okay, on 12th. On 12th. But then let it be on 14th. 14th. Yes, you bring so that I'll send it to mediation, therefore. So all the matters will be over. Yes. 8 and 9, both.
Registered post.
Registered post.
Through
Through IO also. Through IO also. Service through IO, registered post, and all the modes. All the modes. Extra copy you file. You do it in all the modes you let us serve and bring it. Yes. Yes. Extra copies will be served and through IO of the case, the OPA part number 2. 3 copies.
And may I get a copy of the order today? I am not addressing things.
I think it will be done today. Yes. Yes, we will do it. Because after lunch, there is a lunch and all that time. Yes.
I may pardon that item number 36 today, your lordship has directed me to get a certified copy of the 202 statement, my lord. Because the last year's,
I don't need certificate copy. Normal copy also you can give.
my lord.
Why are you waiting for certificate copy?
No, I'm trying to get it, my lord, because of last week's, my lord, that we cannot send the persons to get it. Your lordship may keep it to some any other day, my lord. I will.
Mr. Pal, this is a matter of 2000.
My lord, I'm not taking any time. I only assist to your lordship, my lord. Your lordship was not convinced that.
By way of last and final, you tell me. I don't need certificate copy, just give me.
I will get a copy of chora copy.
That's photocopy, not.
Problem होची.
Don't use those expression in the court. You are liable to be prosecuted for that.
Don't put against strictly.
Only but not less or keep it on 13th,
Yes, my lord.
30th,
My lord.
36, 30.
Only interim order was there.
Entry not to continue. Yes,
No problem.
yes. Yes, mention only.
To mention, Your Lordship. Your Lordship, this is a criminal appeal against the conviction of the Vigilance Court. Your Lordship, it is ready for hearing and it used to be listed until last week, Your Lordship, and it has become delisted. The
Include that in the weekly.
Weekly.
Let's ready.
yes, Your Lordship. Obliged, Your Lordship.
Yes.
Item 2.
Something of the order will be 2723, taking cognizance against the present petitioner who is an advocate, Hon'Ble Bar Milo. Allegation is that your lordship can come to page 9. That's right.
9, huh? Yes. Yes. What is the list?
Both are advocates, my lord. I suggested my friend, but he included the in front of the party.
You include the informant and issue notice. Informant, we implemented the party number 2, issue notice. What are the offences?
I will say you
Oh,
In courtroom, there is a.
it's all right. We'll try to settle it. Have the requisites? Yes, Mr. Arora, what do you say? No.
advocates malta.
Advocate unnecessary. Stay, huh?
I am permitted to.
Sarai, what I'll do is I'll send it to mediation cell, district mediation. No. I'll last day. High Court. No, I'm directly I'm sending. What is this? Shall I send it to district court mediation cell? High Court mediation cell. High Court mediation cell. And see for them. Okay. Let them come.
Yes, let them have it.
Yes.
Obliged.
Stay up the further procedure. Yes, sir.
Item 3.
I'll make party mail right now. Yes. Right now.
Item 3, Malad.
Newly added opposite party notice and both the petitioner and the opposite party number 2 are practicing lawyer on the Barampur Barampur District Court. In view thereof, there is a chance of settlement in this matter and the matter is related to the High Court mediation center. Yes.
Item 3.
Malad, item 3. Item 3, I'm on VC, Malad.
Yes, sir.
Malad, actually, I have a blood test to undergo. This diabetes blood test. May I pray it be taken up at 12 o'clock?
Yes, no problem.
12 o'clock, Malad.
12 o'clock. Yes.
Deeply. Malad,
Item 5.
it is a party. No one else.
It's all right. 12 o'clock, I'll take it.
Malad.
Item
Obliged.
5.
Right.
Okay, I have to recall the witnesses, my lord.
Yes, sir.
I have to recall the witnesses, my lord. 1 to 11, my lord. Last occasion, you also want to know the material witnesses, my lord. My lord, I pray for, my lord, recall the witnesses 3, 5, and 8, my lord.
I didn't follow you. I'm not able to follow you.
My lord. My lord, because recall the witnesses number 11, my lord. Last occasion, you also, my lord, 1 to 11. 1 to 11. In the root and when the council was there, council, my lord, nothing, which represented 3, represented 3 and 5 and 8, my lord.
3, 5 and 8.
Right, my lord.
This is at the last stage of
32 ವರ್ಷದ ಕೇಸ್
huh?
32 ವರ್ಷದ ಕೇಸ್
What is the stage of the trial now? Final.
Finals. Prosecution is early. Did you, sir? What a church one good
Staff. See, petitioner is agreed by the order dated 20th/4/2024, whereby his application under section 311 CrPC for recalling PW 1-11 has been rejected by the ACJM bracket special Cuttack in BGR number 14 of 1992. Then counsel for the petitioner submits that these witnesses could not be appropriately cross-examined because the lawyer who was representing the petitioner has expired. Has expired. Mr. Maharana and counsel for the vigilance vehemently oppose the prayer because this case is pertaining to an FIR of 1992 and the petitioner has been employing dealing tactics at every stage. Every stage. I have perused the application under section 311 CrPC moved by the petitioner and also the evidence placed on record. I am of the considered view that the petitioner being an accused has an indefeasible right to defend himself. He should every appropriate opportunity to cross-examine the witnesses. However, his prayer for recalling 11 witnesses is there is there is no substance in his prayer insofar as calling up for 11 witnesses are concerned. I have examined the relevancy of the witnesses and arrive at a conclusion that out of 11 witnesses, 3 witnesses are vital to the prosecution, namely PW 3, 5 and 8. 3, 5 and 8. 3, 5 and 8. I don't know. 3, 5 and 8. 3, 5 and 8. Therefore, in the interest of justice, the petitioner should get a single opportunity, at least a single opportunity for cross-examining these 3 witnesses. Accordingly, the trial court is directed to fix a particular date and summon all the 3 witnesses, and by affording an opportunity to cross-examine, close the evidence of the prosecution. It is made clear that in no circumstances petitioner would be afforded further opportunity, and the petitioner shall not seek adjournment in the matter. In view of the long pendency of the trial since 1992, it is expedient that the trial court should do well to see that the trial is concluded within a month. Hence, okay. In a month, hence. Yes.
In a month, as expectations, like them, there are not within 3 months.
Within 3 months. Okay. Why I am giving you 1 month? You know, if you give that cap, then the trial court will fix immediately and give opportunity and finish it up. Otherwise, they'll keep on saying somebody. And the petitioner shall not avail the benefit of this order. He shall not be afforded any more opportunity to move any application in that regard. Okay. In that regard.
Here, your lordship have challenged the order of permission taken pursuant to a protest petition filed by the complainant, your lordship.
Yes.
The impugn order is at page 61, your lordship. 61, your lordship.
Okay.
The order dated 12/9/2022, your lordship.
Yeah.
Where the convenience order was taken against all the petitioners, your lordship. The background of the case, your lordship, had annexation number 1. The petitioners filed an effort against the complainant's son that they assault one of the member of the petitioner's family, your lordship, who has been brutally assaulted, shifted to SCB hospital, your lordship. Who have had annexure 2 charge sheet was submitted against him, your lordship, under 307, and he is facing trial in that case, your lordship. When they filed this FIR, your lordship, the complainant group, they filed an 1cc case, your lordship, by annexure 3, which was referred under 156(3), where the final report was submitted that no such incident occurred, your lordship. The complainant was noticed, your lordship. Your lordship may peruse the final report, that is, the relevant part is page 42, your lordship.
42.
42.
Yes. 42. Yes.
Last but one para I am reading, your lordship. During the course of investigation, visited the spot, examined the complainant along with other witnesses and recorded their statement under section 161 CrPC. Sri Ashok Bhadai, IAS Narsingpur PS, pleased to supervise the case. And I'm reading the relevant part, your lordship. Being aggrieved complainant of this case, Savitri Dehury, who happens to be the mother of Kusha Dehury. Kusha Dehury, who is accused in the case against whom we filed a FIR, and he is facing trial under 307, your lordship, made complaint petition before the court. During investigation, no one proved the assault by the accused person of this case to complainant Savitri Dehury. He is on opinion that this false case under section such and such IPC against the accused persons, all the accused persons, petitioner, your lordship, Samsundar Dehury, Pramila Dehury, Vikas Dehury, Bini Dehury, Sunita Dehury, Bimal Dehury, all the family members, your lordship, of village Tarasai, Regada, Narsingpur. Investigation of this case was completed.
False case.
False case.
Yes.
Yes, pursuant to,
And the petition he has filed petition.
no, pursuant to the notice I issued, your lordship may peruse, and filed the enter order sheet, page 47, your lordship.
47. Yes.
The order dated 12/3/2022, your lordship.
Yes.
The case record is put up today on the eve of National Lok Adalat. SR is back after due service, peruse SR as well as endorsement of the process server. It can be seen that the notice has been served on the complainant personally. Despite the personal service, no steps taken by the complainant, and she did not appear. Accordingly, hence the case is closed, your lordship. After the order was passed, your lordship,
13/3/2022.
13/3/2022.
Yes. Thereafter he filed
They filed the protest petition, your lordship. Pursuant to protest petition, lordship,
when the protest petition was filed?
protest petition was filed. That is on 4/4/22, I think. 4/4/22, your lordship.
Acha. Yes.
And then reiterated the same thing, your lordship. In the protest petition was filed, where 200
Just tell me, in the inquiry, who all are examining? Inquiry and two.
complaint. One witness, one of his family, her family member, and the Kusha Dehury, who assaulted us, your lordship, and facing trial under
I
307.
think you just now, Mr. Ragada will tell whether the same witnesses were examined in 161.
No, my lord. He has not, at time listed, my lord. And
I just issue notice. Let's see. This is a very, and the same complainant's son is facing 307. Notice was issued, they didn't come, and they're repeating the same thing. And police have thoroughly investigated. In the same witness.
But in fact, my lord, yes, sir.
No, the case is-
She they did not appear before the court below in portions of summons, my lord, after final court, my lord. But that case is closed, my lord. Subsequently filed 1/6 case, my lord. 1/6 is not my lord protest petition. It's a
It is written in protest.
No.
But in shape of 160, your lordship.
1/6,
But in the index it is written in protest.
yes, 49 pages. Only 1/6 case.
160, and they narrated the same story.
No, is it permissible? You should file protest petition, it is closed. You can't.
It is not protest petition, my lord. Yes, my lord, you can get, my lord.
So protest petition.
My lord.
So therefore, the investigation is completed. His right to file protest petition is also foreclosed.
My lord.
Now he turns around and brings a
Complaint case, my lord.
complaint case in 307.
And the complaint case court, my lord, the whole initial statement and other statement recorded, my lord. the court will have taken cognizance, right, my lord?
No, no,
That vote-
technically you are correct, but see,
Madam.
if there is an offense against the state,
My lord, exactly.
who is to investigate?
The police, my lord.
Police has done it.
My lord.
Fine.
My lord.
Therefore, the procedure contemplated is you have to file protest petition if you are not satisfied. If the evidence in a case of this nature, where the case against state,
My lord.
in the complaint case, how the complaint case is made out on the basis of oral testimony, despite the fact that the police has already inquired and filed a closure report, a cognizance is taken. And particularly in the peculiar facts of the case that the same.
But in fact, when there are the 200 CRPC on oath the complaint.
I may be pardon.
There are two inquiry.
Private complaints are being really filed where the evidence is under the control of the complainant.
My lord.
If the evidences are under the control of the state has to investigate and file a report, which has been done in this case. That is the idea of, that is the scheme of the law.
My lord.
If everybody will start prosecuting complaint cases, then the police department has to be redundant.
Also, I am since
I know, but in the protest petition, therefore, in the protest petition, you can file the protest petition and say that the police has rightly not investigated, nullified this, that. So therefore, the court can take cognizance. That's the idea of it.
Since my lord, what my practical my lord, experience, I am telling one thing, my lord. Since that I have taken the local health, my lord. Local health, my lord. It is not possible on the part of them to come to the local health, my lord. Sometimes they are getting, my lord, this is the ground reality. In local health, local. That is the ground reality. Competent court is the concerned court, my lord. If someone issued from the concerned court, my lord, generally they always, my lord, they wanted our advocate and engage advocate. Local health, my lord, what happened? Parties own cost, own account, man, they have appearing before the court, man. That has been accepted in the court in the local health, man. Not the
My lord, I am issuing notice. You do one thing, you only tell me whether the witnesses he has examined or the complainant is examined in the 202, whether the same witnesses statement under 161 161 you have recorded. If you have recorded, you have dealt with. You will have to compare both the statements. You can't make a statement before the police something and notice. Huh? Yes.
I filed a IF for
an application there.
lordship that on that case is posted on 4th year already.
Application, the trial court will consider. Move an application for adjournment. Yes, before trial court. Yes.
Item 9.
But if you get some judgment,
Yes, Lord. This is in the first.
and on facts only every time you are arguing. Come with some judgment. You have to research on this subject. What is the scheme of law? Whether this kind of after the non-availment of the right to protest file, whether you can file a separate complaint or not. All these things you get some judgment from some high court, something.
Yes, sir.
Yes.
Item 9.
Yes.
May I please know? Item number 9. Same cause of action.
9.
Let this matter be tagged along with that. Notice was issued.
Each notice, same order to be tagged with it. Okay.
Item 10.
I am challenging against the court.
Oh. Yes.
Next year 4, and in this case, what has happened? The opposite party filed under 28 petition as well as a petition under section 12 of the PWD Act. In 125 petition, 6,000 rupees was allowed in favor of the doctor because the opposite party was working as external police. Thereafter, she was dismissed from service on the ground of the production of false cases. And it was confirmed by this.
Who are you?
I am the husband. My lord, I am paying
Your name is very misleading.
the
Therefore I asked. Misleading name. Yes.
My lord, see, he is paying every time the amount of 12,000 rupees toward the maintenance for the wife and the daughter. And as on by the date of issuance of DW, he had already paid 1,14,000. Only 42,000 some odd was left. In spite of it, my lord, DW was issued. Your lordship may kindly see. And I have filed a petition to recall the said order. It was also withdrawn. In the meantime, what has happened? The officer of police station, they came to carry my two-wheeler. It is lying in the police station.
What are you doing?
I am actually working in a medicine shop. Having been
And she is working in the police department.
police department, she was working right now, not because she has already been dismissed for something. My question is whether I am paying. I am paying regularly, and some amount was left. And whether the board can pass. Lordship may kindly see on page 22. 39 page 21. 3924. Lord and Counsel for both the sides are present. Lord and Counsel for OP files petitions regarding the maintenance of this execution proceeding, along with another petition for stay for the proceeding of the execution case. Copy sought on the adversary first on all the petitions filed by the OP. After hearing or rejection of all the petitions filed by the OP, issued a BW against the OP, subject to the condition that on record, the BW, the OP will have to pay deposit the total year maintenance amount in the shape of petitions. Thereafter, part final order. Page 20.
So what is the due according to you?
Right now, in the meantime, I have already paid on page 1024. I have already paid all the amount. 156.
Areas, all the areas.
All the areas. My lord, in spite of it, they have taken seized my two-wheeler. It is lying in the police station.
I will just issue notice, let us see next week to file the process.
Next week, only my share is for release of the two-wheeler.
Oh, no, that is not your place.
Yes, I am having a IA.
Where? Oh.
IA, I am filed. I have filed.
Yes.
I have before the that I have paid in the scope.
Hey, where is the direction for the confiscation of two-wheeler? Then
This has ceased. That is the my lord crux of the matter.
maintenance you are taking. What is this? Payment of maintenance to the wife, you take the scooter, car, whatever it is.
Seizure list is. Seizure list.
Release it.
Yes, ma'am.
Release it. Issue notice.
Yes, ma'am.
Issue notice to so and so in the IA. Mr. Sugata General and Counsel for the petition submits that on the garb of non-payment of the maintenance awarded by the 125 quota. Court
129, section 12 of the
in the DV proceeding against the petitioner, the police has seized the scooter, two-wheeler scooter. What is that scooter?
even the registration number.
Scooter bearing number OD 05 AM 4470 of the petitioner. She has placed, she hands up for the seizure list date is 6/10/2024. To establish the same, the perusal of seizure list reveals that along with the all documents also pertaining to that.
Yes.
Along with the registration certificate, the scooter number so and so has been seized on the ground that the petitioner could not satisfy the award amount to the award amount pass against him in favor of the opposite party. The application is allowed. Which police station is this?
Lakshmi Sagar Police.
Lakshmi Sagar Police Station is directed to release the scooter seized by seizure list dated 6/10/2000. Yes, you will. Okay.
Also certified copy of the Lakshmi Sagar.
Today you will get it. Yes. Don't be agitated about that. Please. No, only you are satisfied with this?
Hello?
Shall I dispose it or notice? Notice. No matter notice.
Hello, 11th, before my friends, I have the responsibility to appear on behalf of the government. And because he's got a.
Yes.
What's here as
Yes. Yeah, he has 5 months.
Arjun.
So he has challenged the petition, rejected on October 11th. Although the matter has been adjourned from time to time, he has given the chance to argue the matter and.
When did he learn to recall who?
because one witness, that is PW4,
The matter is pending as judgment. I am reading the.
that's, I'd made a mention before that yesterday only. My predicament towards here is I've prayed for specifically putting 2 questions to PW.
Where is that? Where is your application?
But my application is by annexure 4, your lordship may kindly see.
Yes.
Page 57.
Yes. Question, column number 9 of the inquest report is what? Filled by you. Filled in by you. Give 3 FIR is written by
I
you.
see the also.
Connected questions according to the answer of this. These 2 questions you want to ask.
Yes, Miller. Because
Yes.
I know the Lakshmi may read along with the order. Order dated 28/10/2022.
Next one.
I know this.
Yes.
Total 2810.
28/10/2024.
2810.
I have 28/10/2024.
2810.
Yes.
Yeah, this one. Okay. Yeah, 2810. Okay. Yes.
On editor of the record,
Yeah.
editor of the record, it's found that on 9/9/24, the defense evidence being closed, the record is posted for argument. On 16/9/2024, argument was started from the side of the prosecution and that was closed on 18/9/2024. The Lord and Defense Counsel sought for argument and record was posted on 19/9/2024 for argument from the side of the defense. Thereafter, the record was adjourned on.
All the days, yes, for argument
All
from
the
the side of
days, yes. And on 23/10/24 for argument from the side of the defense. The argument was heard in part from the side of the defense on the last occasion on 23/10/24 by passing a specific order. The record was posted today for argument as last chance. It was made clear that no further adjournment will be given for the further argument on division of the record. It is seen that the Honorable Court case number so and so have been pleased to direct this court to expedite the trial. That Honorable Court, by disposing of case number so and so, their kind order dated so and so have been pleased to direct this court to pursue the trial, preferably within a period of 2 months from the date of receipt of that.
Yes. I understood. What is seek your application under 211, 311?
Yes, Miller.
When have you filed?
No, that's I have filed 22/10/2024.
And see, you have partly argued the matter thereafter.
The argument it
See, how many days? See, I'll tell you. 18/9/2024.
No, that's I have
28/9, 25/9, 26/9, 27/9. And thereafter 3 the application. Yes.
During the course of argument, it was apparent that you have argued nothing less than 10 days. During and thereafter you didn't wider and then application.
Here the question.
Your velocity could have been, if you would have moved an application, the application is not decided and the hearing starts, then I can understand.
The application under section 41, for putting across the signatures which we have disputed, was also pending. And in the course of arguments, my lords, we had found out that these are the two specific questions which are in our favor, which needs to be confronted. Because the
What prevented you not asking this question?
at the instant
In the application where we said, what prevented you not asking?
we were
Extensively, the witnesses suffered a cross-examination, a very extensive.
the witnesses suffered a cross-examination. After the IO's evidence was taken into consideration, we could find out during the course of arguments, final arguments, that these are the two pertinent questions which were required.
And after 10 time arguing before the trial court, and the 10th hearing, this is a case of, something.
This is a case under 302 Millets. And your lordship will kindly do that the informant here, he has stated that.
So, which witness? PW4.
PW4 Millets.
Same is evidence.
Yes, Millard. Well, the
Very-
evidence is at annexure 3, page 53.
Yes.
What he has stated is, if
Right,
your
come to the
lordship will
question, yeah.
see,
These two questions.
at the Millard's page 53, has your lordship got?
Yes, I'm there.
Page 53, para 3 Millards. At the time of occurrence, I was at Battaguda. On that day about 8 a.m., my cousin Nirmala Kumar Sahu, who is PW3 Millards, intimated me over phone that two unknown persons came in a motorcycle and fired on my brother Abhimanyu Panda, who was the deceased, causing gunshot injury. Getting the information, I immediately went to the hospital where the injured brother was shifted and found the blood oozing out. And I came to know from my DCM that my brother is dead. Police held the inquest at my presence on the dead body of my brother. Let's have also annexed the inquest report. Your lordship will see 2 by 1 in the inquest report what he has stated. Page 19 is the legible.
Come to the cross-examination.
In the cross-examination, he has Millard stated like this.
What are the questions? The two questions are column number 9 of the inquest report and exhibit 3 by. See, insofar as the second question is concerned, exhibit 3 written by you or not, the FIR is already exhibited. Right, whatever it is.
That is the
you want the documents.
he has stated.
See,
Right before Vijay Kumar Sahu, who is now.
I'm trying to do something in your favor.
Millard.
And to examine whether what is the relevancy of these two questions. If it is relevant, then I can understand allowing it. See the two questions.
Yes.
It is pertaining to some document. The documents are exhibited.
Millard.
Whether it is written by you or it is not written by you, the document is there in front of you. You need not put it to the witness. Who is this witness?
Millard.
Who is this witness?
Millard, this witness is specifically the person who will give chance.
You tell me, you tell me the inquest report is there on record or not.
Yes, Millard.
And the FIR is also an executed document.
Yes, Millard.
From the document you elucidate
IO's
what is the relevancy.
The IO evidence states that Millard at para 50.
Who is PW4?
PW4 is the person who has stated that he knows the informant. He is also one of the witness who was there during the time of inquest.
These two questions are not relevant to this witness.
But how are they not relevant? The fact that I was not named in the FIR. These two petitioners were never named.
FIR is there. You can read from the FIR.
Yes, Millard.
The inquest report is there. You can read the inquest report. Who is signed, who is not signed, everything is
The
there.
investigation shows that the IO in his cross-examination at page para 53,
Yes.
he has stated like this. It is a fact that the scribe has not given his endorsement in the FIR. I have ascertained about the scribe of the FIR during my investigation and found that informant himself has scribed the FIR.
Who has said that?
IO has said.
And the FIR is there with you?
Yes, Millard.
It's
And
enough.
in the FIR, what
It's enough now.
What the informant has stated, Millard, informant has stated that FIR was scribed by one Vijay Kumar Sahu,
Well.
who has now died.
Yes. Okay.
Therefore,
To put to it. It's not relevant. You have done very good job, but
Millards, your lordship will then pass it over, Millards, Mr. Panda will place it, Millards, I'll be Mr.
I don't think he can place better than you.
Millards,
Can I make one prayer, Milord? Can I
I
make
can
one
give for
prayer?
I can give for the time. No, you don't give only.
Milord, can I make one prayer?
You are doing better than your the senior Mr. Panda, and you are doing this time in me. I'll definitely pass on, but I'm not allowing to argue. You are.
Why Mr. Panda there?
Let him do that. But you are, I'll pass it over. If you want us to, I'll put it one Monday, no problem.
Millards,
Can
the
I just
judgment
make one
will stand
submission,
first.
Milord?
I'll pass it over. You come with some judgment.
Millards, there are series of judgment because at any point of time, a 311 pictures.
Soon.
There are series of judgments starting from
Timing is not a problem. I can allow this stage also. No problem. That's
a series of judgments of this honorable court, Millards. One is Rudra Narayan Sahu, which was the delay was at any instance if pertinent questions were found. It is there.
Yes.
Look, I have judgments, Millards. So ଆପଣ ତ ସବୁ ଜାଣିଛନ୍ତି ଆପଣ ଆଉ କପି କଣ ଦରକାର ହଁ ଆପଣଙ୍କ ପାଖରେ ତ ଅଛି ଆଉ ସବୁ ତ latest judgments copy ଅଛି.
Which paragraph you are referring to?
Notes all these judgments with regards to 311
In the Rajaram Yadav, which paragraph you are referring?
Millards, I have stated in the first page the relevant paragraphs, Millards. That is in a different case.
Okay.
But this is
Para 14.
Yes.
Para 14.
There's all the judgments with relevant paragraphs.
What is the proposition?
Millards, 311 can be stated to be
That is second one. On that. Even the last day it can be done.
yes, Millards.
But subject to two things. Subject to bona fide approach by you. Second is the relevancy of the question to be posed to the this thing.
Millards, the relevancy here, Millards, was that the informant has stated in his own cross-examination as well as chief that the FIR was scribed by one Vijay Kumar Sahu. That it could not be discussed in the court trial, Millards. And the IO himself has stated at paragraph 53 that it is a fact that the scribe has not given any endorsement in the FIR. I have ascertained about the scribe of the FIR during my investigation and found that the informant himself scribed the FIR.
Now you need not put this one. So when you begin to why you are asking this question?
States that the FIR was scribed by one Vijay Kumar Sahu. Millards, isn't it very pertinent, Millards, to
No, it loses relevancy because of the questions you have put to the IO and all. You can read along with that annexure. That is, exhibit that is the FIR.
Millards, when
Everything is there with you.
Millards, when
Why are you putting this question to this witness to create further doubt?
no, Millards,
You have enough material.
enough to clarify the stance of the informant that we have been victimized because we were not named.
See, the benefit, the doubt has already been created by you by putting sufficient question to the IO and other witnesses. And why do you want to clarify it? You get the benefit of doubt immediately.
Millards, that Millards, your lordship knows that in course of the time when it is a 302 case.
No, you get direct benefit of doubt because see, who is this crime, you have created a doubt on record. By asking that question to this witness, it may so happen that you may evidence has come that may be diluted also. That is a dangerous proposition for you.
In case of clarification, we can only suffice the fact that the informant and the interested witnesses are trying to victimize us. Thereby.
I don't think that question would be much have any relevance. And in the column 9, after the inquest report, what has happened, and that inquest report is exhibited. You can see that document. Why should I ask a witness for that?
Millards, he is the.
I don't see doing any.
He was one of the witnesses to the inquest.
Maybe, but that inquest report is an exhibited document. You see the column 9, what is written. Why should you ask someone?
Millards, the FIR can only clarify who has stated.
You have asked that question to the IO already.
Millards, I have asked, therefore, while drawing the attention during the course of argument, the learned defense counsel felt it pertinent to question.
This question you have already asked to the IO.
The IO then clarified, Millards, here
Yes.
that the informant himself has stated to have scribed the FIR. Now, my lords, the informant is playing hide and seek in the fact that coming with the chief in his own chief examination that there was one Vijay Kumar Sahu who was my friend, he had scribed the FIR.
It's all right. But the FIR is there. Unless something else, that's enough.
Unless PW4 is put across those two questions.
Why will you clarify it? I don't understand. Still, I am not able to understand. You have created enough doubt. You have sufficiently created doubt. And the doubt which you have already created on the record, you want to clarify from the witness. I don't know. Why?
But unless I clarify that the FIR itself, which is questionable.
Generally efforts are being made to create doubt, not to clarify on the record.
Therefore,
So that you get the benefit of doubt.
FIR. And therefore questioning the entire FIR.
Anyway, I'll pass the order. Okay. I'll pass the order. Yes, next.
For the last, for this trial of this case should have been completed so and so, but due to directly.
Because my handwriting report to the handwriting expert which was rejected, if I put the pertinent question to PW4, I'll be able to clarify at least the fact that the handwriting in which the FIR has been scribed and the inquest report both are of the one and the same person.
I don't think that. Yes.
Because in that case, the entire FIR will be taken into consideration with being questionable. Because I am not found named in the FIR, my lords.
Yes.
And the learned court below has fixed the date to 1st, my lords. Therefore, my lords, I am praying at least if your lordship is pronouncing the judgment, until then,
there are few problems with you. One first problem is you have argued for 8-9 days. Thereafter you move the application. First problem is this. Second problem is the questions, two questions which you are proposing to put. Those questions, according to me, is not relevant. Even if I will relegate it to the trial court to give you an opportunity, I have to say that the trial court has to look into the relevancy of these two questions. Okay. If I myself is not satisfied the relevancy, why should I give it to the trial court?
But your lord.
And that will further delay the conclusion of the trial.
But at least your lordship.
And I will keep it open for you to argue this point.
No, lords. That will suffice.
I'll keep it open.
At least your lordship will grant me.
These two questions you can argue at the time of that is open.
Submit before the mistake that document is not with me. Earlier, they have filed a petition under 311 the IO. IO was recalled. At that point of time, they didn't. What is the purpose and intent?
I think to IO they put the right question and they created sufficient doubt. And these 2 points they can argue and the
that opportunity should not
Yes.
That opportunities, 12 opportunities were given. They didn't avail. In spite of it, whether they can be allowed to do the same.
But see, I will tell you these 2 questions they are entitled to argue and the trial court has to deal with these 2 questions.
Let them file a written note. That will suffice.
No. Let them argue. See, 302. Why don't they argue the point?
Well, what's with the fact that how 302 cases are being heard and argued? At least I.
No. These 2 questions, these 2 questions have to be dealt with the trial court very specifically.
My lords.
On the basis of available evidence on that.
That's all. I go down.
That's all. That right go ahead.
I go down.
But my submission before your lordship is that let them file the written note stating whatever.
That will be fine.
Madam, I must tell you, I can't advise the counsel of appearing for the defense whether they will argue orally or written argument. That's their prerogative. And it is a 302 case. And they have an indefeasible right to defend themselves. I can't stand in their way.
Keeping in view their conduct, your lordship
With respect to conduct, Miller, here the learned court below has given reference to two BLPL numbers. There is another BLPL number which was given for all these things. Adequate opportunity, needless to say that opportunity has to be provided to both the parties to place their cases.
No. Please.
Yes. That is,
Okay, leave it to me. I'll pass a balance order.
Yes.
I'll pass.
until then, my lords, the judgment should not be pronounced.
Yes, next.
Therefore,
You argued so well.
Lords, I am obliged, lords. Until then, my lords, your lordship will pass certain order. I'll be able to produce that in.
Today I'll just now in the lunch hour I'll do it.
Obliged.
If your senior Panda would have been argued, I think I would not have given this much indulgence.
I am grateful. Therefore.
You're doing very well.
That's
Yes.
why I sent him to argue.
Lords, may I pray the bunch of documents I will supply a Xerox copy.
Yes.
This is the only bunch.
Yeah, definitely.
Your lordship will.
Yes. Today itself, because first the matter is there, so I'll upload it.
But I will supply a copy of the Xerox.
These are undisputed position of law. Yes.
May I please? Here, my lord, this arises out of an NIF case. It's a 160 case where the case was contested, and on the date of pronouncement of judgment, neither the advocate nor the accused were present physically. It was by inadvertence, and for that reason,
NW.
yes,
At page, I'll recall the NW go and appear.
my lord, yes, my lord. Or else it will be adversarial because, my lord, thereafter, if I apply for this suspension and I go for coming for leave, it may.
What do you want?
I want recall of that NW. That's all.
I'm recalling.
Yes.
When are you going to appear?
My lord may fix it. I think that matters.
You can debate before 20th or 25th. 25th is the number. On or before 25th number and record. Okay.
13. But FIR on 13/8/2021 and he was released on 22/10/2021.
I think you're doing it. Yes. Release on bail on
22/10/2021 and the NVW issued on 16/9/2022, my lord.
22.
Yes, my lord. On the day of charge.
500. 25th. 25th. 25th November. Okay.
14.
Petition was released on bail on 5/2/99. The NVW was issued on 18/4/19.
19. 1000. Yes.
15.
May I please the lordship, my lord? The petitioner was earlier on bail on 21/4/2022, my lord. And due to non-appearance, my lord, the NVW was issued on 31/8/2000.
500. 24. 31/8/2024.
24.
Yes.
16.
The petition was earlier on bail since 14/2/2020 matter.
Yes.
And NVW was issued matter 7/1/2020.
22. 500. Yes.
17.
Yes, sir.
Mr. Mahanti, I am passing ahead on interim bail on the ground of illness of his wife.
Verify. Mr. Rao, verify it. Next week. Next week.
Except 18.
Except date, any date. We give. Verification. Yes. On the petitioner has moved an application for interim bail on the ground of illness of his wife, and he has enclosed certain documents in that regard. Mr. Rahul appears for the state and seeks time to verify the document. Please.
The possibility for service.
We file it. And give a copy so that we can verify. We will not waste time. Yes.
18.
My second call.
CD is not come. Call for CD. Next week detail. Call for CD. Okay.
So file the copy of the material, please do the exam.
Yes, you can.
Copy.
You need this copy so that you
Already given also online.
online. Yes. Yes.
Beg pardon, my lord. Item number 19, your lordship. The petitioners are in judicial custody since 20 May 2023, my lord.
20 May
2023. And as per prosecution allegation, my lord, there are 4 persons and they are transporting 38.600 kg of contraband ganja each. Total quantity of contraband ganja is 154 kg, 400 gram. Previously, your lordship called for the status, that is flag D, may kindly peruse.
B.
Flag D. There is a noting, my lord.
D for Delhi.
Delhi, my lord.
Where is flag D? Yes, flag D, yes. What status of the case, huh?
Status report dated 3rd October 2024.
Okay. FIR is it?
FIR dated 19 May 2023, my lord. In the charge.
And what about the antecedents?
No antecedent. So for the 3 present petitioner is concerned, your lordship.
No, the report says that the accused Abhijit Vaidya has no criminal antecedents.
My lord, Abhijit Vaidya and other 2 are also no antecedent, my lord. Subject
There is
to
nothing. And the matter is not shown 4/11/2024.
Pardon my name, Sobaita appearing, my lord. In BLPN number 1851 of 2024, my lord. He's a local boy, but having no criminal antecedent, 18-year boy, my lord.
What about this first witness, first accused? Abhijit Vaidya is from?
My lord, Abhijit Vaidya and Swapnil Sende. Both, they have no criminal antecedent, your lordship.
But they are from Maharashtra.
Maharashtra, my lord. Subject to verification of antecedent.
What about
So, my bail application in 1851, my lord. He's a local person, my lord. 18-year boy, my lord, having no criminal antecedent.
You will file affidavit.
Yes.
Affidavit regarding your antecedents, and insofar as the outsides are concerned, you give your declaration that where you stay, your phone number, and some your parents particular and everything. Actually, 1 year you have already been in custody, and you see Ravi Prakash judgment and give me.
Grateful.
And you put it next week. You give it on 13 go 13. You file some affidavit, and I will not advise you what affidavit. If I am not satisfied, I will reject it.
My lord.
Satisfy the affidavit.
My lord.
Antecedent and everything. Yes.
Grateful, your lordship.
20.
Notice
Informant is. Have you heard?
Notice of not served 1 week. Time is necessary.
1 week time is the last of opportunity. Notice on opposite party number 2 by the IIC.
My and senior has also filed the requisites.
IICFO, which police station?
Navarampur.
Huh? List there. Yes.
Raigad.
Not already filed.
That should be Raigad, not Navarampur.
Raigad. Make it over file. See, whatever he says, don't go by that. It should be filed. Yes.
May please, your lordship. The lordship, the petitioner is inside the custody since 22/2/2024.
22 to 2024. 22 to 24. Yes.
The petitioner is the mother-in-law and the informant is the daughter-in-law.
Yes.
Your lordship, the allegation is that 498 326A. Allegation is that the mother-in-law throws some liquid substance which.
And the charge sheet file?
Yes, your lordship, charge sheet since 27/3/2024.
Where is that? Have you filed it?
I don't have the charge sheet copy. My lordship senior must have.
Charge sheet file under for which offences?
Under same section. 498A and 326A.
498A and
326A.
Sorry?
326A.
And 320.
The page 15, your lordship. The
Forensic laboratory also it has proved that those acid is there.
Acid there.
Yes.
Your
Now,
lordship,
what is the injury?
Injury is face injury, lordship, with acid.
Your lordship, I have
Okay.
filed the
Thank you.
injury report. Your lordship, kindly have a glance to page 15, the injury report.
Yes.
Lordship, half inch and to half inch injury simple, your lordship. Showing that simple injury, your lordship. Sufficiently punished mother-in-law and daughter-in-law dispute between. This is a lady of 70 years old.
Where is that? Where does it say simple? Yes. Which
Yes,
part of
lordship.
the body? Which part of the body?
Forensic laboratory report, lordship. Acid.
Yes, one plastic bottle containing mixed water from the veranda.
The liquid super also in the preliminary test also, liquid super changed to red to blue, lordship. Sorry? Liquid super also changed from the red to blue, lordship.
Yes.
Next is the forensic laboratory report also it has been tested.
Turned red, indicating that the acid nature of the water. And the plastic bottle is also found from the
spot.
veranda.
Yes.
Veranda.
That household acid bottle which was kept for cleaning the toilet, your lordship, that is the matter.
And that should have been used in toilets,
Yes, your lordship.
not somebody's person. The informant is already included. Include the informant. It's include the informant. Opposite party number 2. I'll give you the bill, but let the informant do that. Let us see. Her face is, see, I'll tell you, she is a young lady. And you have used acid. I want to know whether her face is defaced or not. If it's defaced, that can't. See, for a woman, it is very dangerous.
8 months in, I am inside.
Sorry, all right, you are entitled to bail. I'll give bail, but let us see.
So
See
also,
the
another
face of the girl.
70-year-old lady.
70-year-old, and the allegations are just see.
Yes, yes.
You thrown acid on the face of your daughter-in-law. If the face is completely defaced, I will not give the bail.
Your lordship, there.
Let us see, because
yes,
see, it is not a concentrated acid.
No.
Water mixed with it, so therefore, face might not have been defaced, and because it is simple in nature. So therefore, let us, just hear her. The consequent petitioner seeks to impede to the informant in the case is the opposite party number 2. Issue notice to opposite party number, newly added opposite party number 2. And the IO of the case is also directed to serve the opposite party number 2. Okay. Returnable, keep it on 13. 13. Okay. And immediately you impede and give an two state conference. Okay.
Yes, yes. Reopening day, I will file the consolidated copy.
Through IO, Mr. Rodham, through IO, please, yes.
22.
On behalf of Vishwajit, that minor petition was written on section 355 and section 25 and 27 of our.
Yes.
And is in custody since taste.
Okay.
And
Yes. It is there?
Yes, sir. 16 and 70 there.
Yes.
not identified.
Sorry, sir?
I put the affair. Unknown persons. Then
Here that has not taken.
No.
Recovering the allergy.
What is recovered? What about your criminal antecedents? You have any case?
16 criminal incident.
Oh.
Similar in nature.
Criminal antecedent, you are arrested.
What is the recovery? You tell me whether on the basis of confessional statement he has been apprehended in his case. No TI correct. No TI correct. And what are the recoveries?
Prior to already there, that has not been acted upon till date. But recovery there.
What are the recoveries? You just ascertain and tell me so that
yes,
you please read it properly.
Yes.
I'll put it next week or so. 13th week or 13th. Okay. Yes. Yes. Let him go. Just go. Yes. Next.
23.
You tell me what are the recoveries? Yes.
20 being to see.
Yes.
In corporations 9/7/23. Quantity 420 kg. But so far as your lordship may kindly see your lordship's order.
Yes.
Out of 38 witnesses, as on date only 8 witnesses are there.
Yes.
Your lordship was pleased to pass an order on 2/8/2024.
Yes.
Lordship may kindly see that order.
2/8.
2/8/24, that is another 3 page set.
Yes. Yes.
I have highlighted 2 points. One, my lord, out of 4 motorcycles were seized. And in each motorcycle.
Oh, 60 kg, 60 kg. Yes.
And that apart, the petitioner was enlarged on interim there, but surrendered in due time. So that 2 aspects was taken note of by your lordship. And also your lordship was pleased to observe to file a petition for bail.
Yes. It has been rejected. What material witnesses? How many witnesses are there?
32. 30.
And how many of them are examined right now?
8.
8, huh?
And I have also given the 8 witnesses who have been examined, they didn't say anything against me.
They are material witnesses.
They are some are official witnesses. And
I'll call for a report from the.
Your lordship was pleased to call the report. Your lordship may kindly see your lordship order.
Where is the report? 27?
8, 2024.
Okay. Twenty-seven eight, huh?
Yes.
24. Where is the report? Hasn't come. Not communicated, it seems.
My submission before your lordship is that since due to delayed trial in view of the judgment of the Honorable Supreme Court and keeping in view in mind.
It is not very delayed. It is only 2023 FIR. 2023 FIR.
My lord, charge sheet was submitted on
Delayed. It is not. But anyway, persons to the order dated 27/8/2024, the report from the additional sessions has come, Special Judge Fulvani in District Kandhamal regarding the status of the case pertaining to status of the case in the file of CT case number 100 of 2023 has not yet been received. Not yet been received. Therefore, the court below is directed to submit a press status report by next date of hearing. Release the matter on 14th. 14th. Yes.
Why not earlier? Because your lordship was pleased to almost
400 kilos. Wait.
400 kilos. Exactly kg.
For 1 lakh. Then all of them will come, then it will be 400. Na? So one will grant bail to one, then the other will come 60, 50. Then I think by the accumulated, you will be 400. Let us see, he's in custody since only July 23. I'll get, see, there is an already there is an order, the report has to come. Let us see. Yes, next. Yes.
24.
May I please ask? The petition is composition for 1/7/2023.
1/7/23.
My lords.
Yes.
Offense under section 364, 302, 201, 120, 34 IP lordship. Implication of the present petition only on basis of the confession of the co-accused on Rajiti Krishna lordship. The fact remains
necessary.
Case diary. State council has not received the case diary and release matter. Yes. I'll just come back. See you.
चिठी म कराइछि
Just give it.
Six.
0606.
10.
No, that is
1048,724. 1060. Yes. It has been taken for that, but it has not come.
But that is in some other assignment. No?
Same.
I can't tag it. When the date is fixed there?
Kuch. It is 5 से पे कुछ.
Okay, check it and next week check. Okay. Next week, see, there is some confusion. Let us clear it. Okay. Yes, please. Yes, item 3.
Hello, this is an application
26.
under 482, my lords.
Yes.
It is against case lodged by a prosecutor. The case is highly improbable. Well, her story is, I'll take a lordship to the documents later. Her story is that she had come with her brother to the house of to the office of the accused seeking for a job. Now her brother goes away and she sits in the office of the accused and it becomes evening. Then she asks the accused to drop him at her house. So he says okay, and he's an engineer in the Tata distribution company. He says okay, I'll take you. So they went by that car. And in the middle, there was heavy rainfall. The driver is in the car and she alleges that the accused rapes her in the back of the car. And the car gets stuck in mud. Anyway, next day morning, the villagers come and they take out the car. She doesn't make any allegations against such.
They were inside the car whole night.
They were inside the car.
All three of them.
All three of them. And she doesn't raise any objections. She doesn't state these facts to the villagers, nothing, my lord. And then she goes away. Then 2 days after, she returns to the office of the accused, to the house of the accused. And thereafter, they say she's a married lady. And she says that I would want you to marry me. And he agrees to it. Then they go to the house of the prosecutrix. Her parents also agree to it. Later on, her cases, later on that the accused has turned around and is not marrying me. Now, my lords, FIR is lodged after 1.5 years, 1.5 months. And on top of that, the prosecutrix is also dead. This is there is a direct judgment of the Supreme Court where a married lady, if she alleges rape, my lords, that is not to be believed, my lords. And my lords, under the circumstances, what useful purpose will be served if the accused faces a criminal trial, my lords? Because the prosecutor.
The Supreme Court says that married lady can be raped also.
No, my lords. If she willingly has sex, if she willingly resides.
See, the willing or not, no willing, that will be, elucidated in the trial only. I can't at this stage. The improbability, what you are trying to say, maybe that on the next day when the rape has taken place, the
Rising out of the vigilance proceeding, your lordship. The FIR dated 13/8/2020. 13/8/2020.
Okay.
I am the establishment inspector in the office of the additional Tahsildar, Sambalpur.
Yes.
And the FIR was lodged pursuant to the earlier FIR lodged against my father-in-law, one Suresh Chandra Mehta.
Yes.
And as against my father-in-law, as of now, the charge sheet is yet to come. And so for departmental proceeding, it is stayed by the Hon'Ble High Court till completion of the criminal proceeding. And so for vigilance proceeding, your lordship, in respect of my father-in-law, it was targeted that within 4 months you have to file the charge sheet. And in the meantime, more than 1 year has been passed. And in the FIR,
That it has not yet been filed.
এই কেসରେ এটা 22 ରେ ଫାଇଲ କରିଥିଲେ ମୁଁ
Like the FIR is of 2020.
20 ର କିନ୍ତୁ 22 ରେ ଏଟା CRMC ଫାଇଲ କରିଥିଲେ I have to take instruction.
by that time, 2 years passed. And
Is there any stay operating?
ନାଇଁ ଏଥିରେ
stay in my father-in-law's case.
But the father-in-law is also a co-accused.
No.
Not here.
That is in respect of another case.
Certainly. Initial FIR was lodged against my father-in-law.
Yes.
Vigilance case number 1 of 54. And after 2 months, this FIR was lodged. And it's the one president in your lordship.
Yes.
And
Okay.
the informant is DSP Vigilance. On getting reliable information,
Why? It's a DA case. No, that's right. But 2020, charge sheet has not been. I'm not propagating that the delay. The thing is that I have to take instruction whether the investigation has been raised. 22 ରେ file ହେଇଛି.
2-3 times.
Yes,
Date has already.
in any case, doesn't know it, lordship can also direct for early completion of the investigation. Why should you need the court director? It is not necessary. In the oust case, on that count, the vigilance proceeding cannot be quashed. See, I'll tell you one thing. If you lodge the FIR like this, and the government officers, they have to keep on suffering for years together, you don't file the charge sheet.
Your
lordship past experience in a DA case, your lordship knows everything we have to escape. They are practice of hiding things. So it's very easy for an IO to file a case upon someone. No. And his service is completely ruined and he will keep on. If that search is conducted, a matter found in his house on the basis of the DA is made out. Still they are conducting investigation. It's fair investigation. For the proper fair and proper investigation, delay is caused. And it is to be seen whether he is delay is attributed to him or not, whether he is cooperating or not, whether he has produced a relevant document or not. It is to be seen. There are so many aspects in delay. We are depending upon other. The FIR in the present case is rated on 13/8/2020. Land Council for the petitioner submits that as yet the charge sheet has not been filed. The petitioner is suffering the ordeal of the investigation for about 4 years. for about 4 years. At this stage, Mr. Maharana, Learned Counsel for the Vigilance, submits that he would seek instruction in the present case because the present case was filed way back in 2022. Therefore, he could not obtain the instruction. Leaves the matter on 18th of November. By that time, the Legal Counsel shall submit a status report regarding the stage of investigation. With this, yes.
Item 30. I will be granted to file it as requisite in order to.
You have got a stay?
No, my lord.
Yes, 2 weeks for the time. Yes.
31.
31, my lord, in course of the days, you will appear. It is a matter of compromise also.
Yes.
I am appealing for the opposite party, not to. And the victim also present, my lord. The opposite party.
He is there?
Yes, ma'am. Yeah, absolutely.
What about your client?
My lord, again, this subsequently another FIR was registered, my lord. That's it, my lord.
Who is registered?
It is the case that they have compromised.
Item note. Yes, my lord.
No, one more FIR against the same.
Yes, my lord.
By the same.
Yes, my lord. After, yes, my lord. After, yes. Say FIR, can see.
Call her.
No, compromise.
Call her. Now the law changed, therefore he is those were the IPC offenses. Now businesses
And I also present.
yes, madam, ଆପଣ ଆଉ ଗୋଟେ କେସ୍ ଫାଇଲ କରିଛନ୍ତି ଏଇ ଯୋଉ ପ୍ରଥମେ ଯୋଉ କେସ୍ ଥିଲା ଯୋଉ କେସ୍ ବର୍ତ୍ତମାନ ଚାଲିଛି କୋର୍ଟରେ ସେଇ କେସରେ ସେଟଲମେଣ୍ଟ ହେଇଗଲା ଆପଣଙ୍କର?
It is my instruction that there is settlement proposal.
Yes. And what settlement you file?
I cannot say.
You obviously ଏଇଟା ଏଇ କୋଉ ଘଟଣାକୁ ନେଇ ଫାଇଲ କରିଛନ୍ତି ଆପଣ? ପରେ କିଛି ଘଟଣା ଘଟିଲା?
Taken to her.
Instruction will not be given to that if that is correct. And I will do this.
She was pressurized. No, you do that, but see, if you are trying pressurizing her to settle the dispute. No, I'm talking about your client. Yes, of course.
A proposal is there. Everything will be.
ଆପଣ settlement କରିବାକୁ ଚାହୁଁନାହାନ୍ତି?
IO को तो रखा है मतलब IO आंसर मतलब I was thinking.
No, as per notice
there. I will solve everything. Next will go.
What was the allegation?
Allegation of that is there, and they have relationship when the person is transferred to another place.
They are not married, or
She is married.
he is already married somewhere else.
There are this must have been filed. So I will verify from my friend and I will come back to you next week.
I'll not say anything. Let it be. I understood now.
It's minor.
And the affidavit which has been filed are also with me, but I do not file on that. You are also I was online. You are also told me that if there.
No, that is the reason I am insisting that accused and complainant should be there. Now you very clear. Anything can happen.
You have to notice if there is something else.
And many a time what happens is they turn around and make allegation against the lawyer.
Yes.
Also may be that's why his relevance is very dangerous.
ମ୍ୟାଡାମ ଆପଣ ଏଫିଡେଭିଟ୍ ଦେଇଥିଲେ କେସ୍ ଖତମ କରିବା ପାଇଁ କିଛି ଏଫିଡେଭିଟ୍ ଦେଇଥିଲେ? ଆଚ୍ଛା ଠିକ ଅଛି ଆପଣ ଯୋଉ ଆପଣ କୋର୍ଟ ଅର୍ଡର କରିଥିଲେ ଆସିବା ପାଇଁ?
Yes, my lord. This is the notice, my lord.
Okay, inshallah. ଠିକ ଅଛି ଆପଣ କେସ୍ ଖତମ କରିବାକୁ ଚାହୁଁଛନ୍ତି ତ? I am putting even
Notice
Voting देखना है voting I have not hired a liquid.
I understood it.
But in fact, last
That my lord.
my friend was there looking at yes, sir. Written in your
How could say appear, my lord? I understood it. Yes. I'll list it on Monday. Tuesday. You just tell me. If the case, you withdraw. Let them do whatever they want. Yes. You simply make a statement. मतलब 10 minutes to come to now I understood it. Yes, ma'am. Yes.
Okay, so report has come from the general sector extension of
Extension of time. Flag. Was there any time bound direction? No. Was free to direct the report to the case within 6 months. The above case could not. That was a 10 to 24 from the time that is on my team. Despite all possible efforts. Flag A. So that is the reason I tell you. Fixing the timeline for the trial court, sometimes impractical timeline fixed. This matter is listed on the Judicial Magistrate First Class Cuttack, while later dated 8/10/2024, has requested the court for extension of time to complete the disposal of DV criminal miss case number 326 of 2018. This court, by the order dated 8/4/2024, directed the trial court to conclude the aforementioned case within since 6 months has expired and the trial court could not complete the trial despite the best efforts. Further 6 month time has been sought for. Taking into consideration the reason, taking into consideration the fact scenario of the present case, the request made by JMFC Cuttack is accepted and the time is extended for another 6 months for disposal of DB case number 4. Yes.
33.
My lord, for extension of the date of surrender, my lord. Earlier, lordship was directed to surrender the petitioner on or before 36/2024.
36.
My lord, the petitioner is a businessman and
how much time you need now?
Another 1 month.
30th November. 30th November extended.
Till then, that MBW
for the reason stated in the application, the time for extension to surrender appear before the court bureau is extended up till 30th of November.
Till then, the MBW is kept in
NBW issued against the petitioner by order dated 29/11/2012. The execution of so is a stay. Why are you asking time and again?
My lord, he is staying out of session, my lord. He is
and he made clear that no further extension shall be granted.
Only 1 month.
And the subject to? I am not impose any cost that time. That is the reason you are coming.
The cost is 1,000 cost.
Right, 49.
Page number 2 rate. Lordship's order. Paying cost of 1,000.
One more, 1,000.
1,000 more.
One more, 1,000, subject to 1,000 cost.
But 1,000 before consent court.
Consent court you want?
Okay. Consent court.
Obliged. Consent bar.
Consent bar. Yes.
Consent, yes.
34.
Consent bar means you must tell which bar. You write consent bar again, it will go somewhere else.
I'm just.
You please give it,
But district bar association, Narcotics.
Narcotics. District bar, yes. Yes.
134.
34.
Mother 130 NI case was filed against me.
I was convicted. 5,20,000 was directed to me, recovered from me. I challenged that in appeal. In the appeal, as per the amending act 143, 20%, 1,04,000 was directed to be deposited. He could not deposit. He was arrested and taken to custody. I filed an application that I am depositing 5%. You accept me. I am suffering from cerebral patient, suffering from yes. What happened then? That was also rejected by the land trial court. I am in custody since month of July.
130.
And my
Where is that order? Where is that order?
Yes, but that order is under Annexure 1, page 9.
Okay. Right on.
Your Lordship has dealt with the similar matter and provided.
138 appeal is pending, 5% you are ready to pay.
Yes.
20% you have to pay.
Yes.
On installment you pay.
The same matter I will argue your Lordship has passed that order. My Lords,
Custody since?
my Lord, I am in custody since 20th of July 2024. My Lord has dealt with relying upon a judgment of a coordinate bench.
No, this was for installment, it was declined. So I say that you go and move it. By relying upon.
You to pay 5% now.
You pay 5%, get come out from the building, and the remaining amount you move application and get it.
I mean, you have your Lordship's order.
Yes, yes. Right.
Your Lordship will note that in.
Yes, yes, yes. Petitioner is agreed by the, where is that in order?
Malada, page 9.
9. Agreed by the order dated
28/8/2020.
28 official after the year whereby his whereby his application for what was the application?
Well, the application was
his application to allow him to deposit 5% of the compensation amount to begin with and release him on interim bail has been turned down. The petitioner has been convicted convicted for offence under section 138 NI Act for having for the reason of take up rupees 5 lakh.
5,20,000.
20,000
on 16/3/18.
on 16/3/18. The petitioner filed filed criminal appeal number 16 of 2018. 2018 against the conviction and sentence passed against him. While admitting the appeal, the petitioner was directed to deposit 20% of the compensation amount
1,40,000 within 90 days.
Within 90 days, as contemplated under section 148 capital A of NI Act. Petitioner could not deposit the said amount. However, therefore, he was taken into custody on.
No, he was taken on 20th of July 2024.
20th July. At that point in time, he moved an application before the trial court offering 5% of compensation amount and sought and pray for interim release so that he can arrange the rest 15% of the compensation amount to be deposited as per the direction of the appellate court. However, the said application has been rejected by the impugn order. Hence, he has approached this court. Mr. Bose, learned counsel for the petitioner, has relied upon the order of this court dated 29/1/2024, passed in CRLMC number 24 of 2024, whereby in a similar circumstances, this court allowed the petition granting liberty to the petitioner therein to move appropriate application to pay the 20% of the check, 20% of the compensation amount directed by the appellate court to be paid on installment basis. Relying upon the said judgment and the judgment passed by this court the order passed by this court on 14/2/2023 in CRLMC 489 of 2023. Mr. Bose submits that he may be allowed to deposit the total compensation amount of 20% on installment basis. Regarding head to the orders cited by Mr. Bose at the bar, I'm inclined to allow his prayer. He is given liberty to move appropriate application before the court below. Insofar as the imprint order dated 28/8/2024 is concerned, the same is set aside. The petitioner is directed to be released on bail, subject to accepting 5% of the compensation amount. And insofar as the remaining 15% of compensation amount is concerned, the petitioner is granted liberty to move appropriate application before the court below. If such application is moved, same shall be considered on the basis of the order dated 29/1/2024, passed in CRLMC number 24 of 2024 and order dated 29 as 14/2/2023 passed in CRLMC number 489 of 2023. See that you do it today itself.
I also dispose of.
I as well as both are disposed. Yes.
35, my lord, if I don't put your lordship to inconvenience, can I get it today?
I have already told. It is a bail order, you have to come out, obviously. Yes.
Grateful, man.
Yes. उसकी submission कर दो. ठीक. Yes. 35.
35, this IA has already been considered by your lordship on dated 25/9. Sentence has been suspended. This appellant has been granted bail. Fine has been stayed. Fine has been stayed.
Paragraph 5 on that day, Mr. Section 5, I must be the appropriate application.
He's asking for adjournment to see. Adjournment to see.
Let it be posted to January.
Yes,
LCR, TCR may be called. TCR has not received.
TCR, call for TCR.
So let it be posted to January.
38.
Partly complied. Paragraph 7, partly complied and partly not complied.
Say your energy to argue in January as you stated.
No, your lordship has fixed so many cases, Mr. Lawrence Senior Counsel Jaswant Das, Mr. Dhara and Mr. Padi.
Stay of condition.
No, hearing of the appeal your lordship has fixed.
But nothing is happening.
Part your lordship has fixed. No, my lord, I am praying that in this order, paragraph 7 may kindly be
see.
Partly complied, partly not complied. Listing has been made.
Then let us see when we will come to see. Because he doesn't have the file also, he can't help you. Yes.
Immediately. The order of cognizance is under challenge as page 20.
20?
Page 20 is the complete cognizance order, madam.
Yes.
447, 448, 506, 34 IP.
Yes.
The case, madam, for this simple application.
Last hearing, your lordship was directed to the petition counsel to take the instruction regarding what is the status of the case.
Status, my lord, after stay has been granted, the case is still continuing, my lord.
Sorry.
Stay has been granted. जो थिला सेट है आप किसी proceed करने.
अच्छा, this is 2016 matter.
Here what happened, my lord? The self-same offence, FIR is lost. And the lordship kindly detailed inquiry has been conducted by the IO, page 13, regarding dispute regarding allotment of a quarter between the parties. Regarding allotment of quarter, everything has been disclosed. Accordingly, the IO has submitted the penal from mistake of fact. After 4 years, for the self-same offence, a protest petition was filed And after recording the statement of the complainant, this cognizance order has been passed.
After 4 years.
After 4 years, ma'am.
Where is the proceeding before the trial court? Show me. Notice was issued when? After the closure report filed, when the notice was served?
Your Lordship kindly see.
On the complaint.
Page 14 is the, page 14, my lord, mistake of fact.
No, that's right.
But then my lord, 2000.
When the court has issued notice to the complainant. If the court issued notice subsequently, that day is relevant.
Here, disclosed, my lord.
Show me.
In complaint petition, my lord.
Yes. When has he received the notice?
Yes, that.
Yes.
Thereafter, the page 17, the complaint went to PS and filed FIR number so and so, and promised to register the substance of, but surprisingly, the police filed his final report to the FIR of the complaint filed on 14/9/2011 on the ground that it is a mistake of fact. Hence, this complaint petition filed in same of FIR, it is submitted the accused person liable to such and such matter.
No, when he received the notice?
That I have to obtain.
That's the relevant thing. If say delay is 4 years, then you have to tell me. If he would have, he might have received the notice lately, therefore filed the protest petition lately. That's what is the relevant point. For the purpose of obtaining a stay, this is a good point. But when final hearing, you have to satisfy.
Naturally. But entire thing based on.
4 years sounds good, no problem. For stay, it's all right. But you have to satisfy me. That is the only ground you have.
I'll obtain the entire order.
That is the only ground you have.
That is the only ground.
Then you have to show me the proceeding.
My lord. Lordship fixed any day next week by tomorrow.
Next week, 11th.
11th.
To get the proceedings.
Yes, everything.
When the charge sheet was filed and when the notice, the trial court issues notice to the complainant.
39. Interim order. May I prepare?
No, interim. Yes.
Wait, please.
Yes.
Here, my lord, the petitioner has challenged the order passed by the magistrate. My lord, directing the petitioner, who is the complainant in the present case, to obtain sanction under 197 to prosecute against the acting persons. The facts of the case is like this. Petitioner is a sawmill owner.
Yes.
On the date of occurrence, while he was in his house, the opposite party, 2 to 8, they came and they forcibly, try to enter the sawmill premises and forcibly wanted to demolish the system. Petitioner had shown the order passed by the Supreme Court in WPC number 1974 of 2009 and WPC number 32417 of 2011.
Yes.
But they didn't care for that order. Using some obscene words, they demolished the entire system. He made an information before the local police. Local police didn't accept the affair.
Yes.
So he drew the attention of the Superintendent of Police under 154(3). And accordingly, affair was lodged under Annexure 1, 323 to 94, 447, 379 by 34.
Yes.
And his investigation was carried on, a final report was submitted.
Yes.
After submission of the final report, petitioner filed a protest petition. BC Annexure 3. Inquiry was conducted. If I will go through the recitals of the complete petition, I will see. At page 22.
Yes. I'm there. I'm reading that one.
Well, इस एक WPC नंबर 100 मात्र बुदाला माने महामान्य हाईकोर्ट ऑर्डर को जन जन कर पढ़ी तहिर महत्व न बुझी खराब भाषा रे हमको सहस सर्वसाधारण साक्षी मान उपस्थित रे गाड़ी गुलाज करी जे ऑर्डर किसी मूल्य नहीं खराब भाषा रे गाड़ी देले so दे हैव डन ऑल मिस्टेक्स my lord, I have managed also the initial statement of the complaint.
How many witnesses were given initial statement?
My lord,
Page 24, except page 24, there is nothing.
my record. My initial statement and inquiry under 202.
Just see para 3 of page 24.
On the alleged date and type of occurrence, accused persons along with other people forcibly entered inside my sawmill. After breaking open the lock of the day, I got information and rushed to the spot and found that the accused persons were cutting all the machines of the sawmill.
Yes, how will you get over that and page 25 para 3 and 3 to 5 and page 26 para 3 to again 5? How will you and para page 28 para 2?
Get over this, madam.
The inquiry has taken place. They have all of the witnesses have said.
They came, they abused whether the actions of the opposite parties, those who are public servants, that is coming under the ambit and scope of 294, 379, that has been dealt by this honorable court relying upon.
You are asking of sanction, regarding sanction.
Yes.
In the absence of sanction, no cognizance could have been taken. That's what you are saying.
My case is, Ballard, that he should not have, magistrate should not have asked me to obtain sanction against that.
Where is that magistrate's order?
That is Ballard as page 32.
32.
Madam. Relevant is Ballard at page 33. Hence, as the present accused persons had been to the spot of the incident in their official capacity, and those exist as a reasonable and connection between some of the alleged acts of the accused persons and the official duty of the accused person. Therefore, there is need of prior sanction of the government as contemplated on 197 CrPC to proceed further in this case. It appears that the protest petitioner has not obtained any prior sanction to prosecute against it.
Yes, what is it?
That is, law is very clear. 2023 volume 12.
Yes, sir.
My lord, I may pray to the your lordship, my lord. There are opposite parties, the government officers are there from 1 to 8, my lord.
1 to 8?
2 to 8. 2 to 8, my lord. And one is expired, my lord. Among them, yes. And another, the rest of OPs have submitted the written statement.
I'll set aside the impugn order and leave it open to the accused person to raise all these points at the right time.
Yes.
How can see the nature of allegations, and the complainant can't be asked to get sanction. The law is very clear on that. And if the sanction is required or not, the accused persons will raise the objection at the right time. If they want of sanction, the charge has to be, they will be discharged. Then let them move application, argue, whatever. I'll set aside. What do you say?
My lord, you will kindly allow to me. Keep it on Monday. I will clear it. Yes.
The law is very clear what to do. Let's see the judgment, or see the judgment of silence. Take the citation. It's very clear. Yes. Which para you are reading?
My lord, the next para, all the Supreme Court judgments have been taken note of. That was the only point.
The only point is whether in a protest petition, if the cognizance is taken on the basis of the facts of this case, whether the complainant could be asked to get sanction. A direction given to the complainant to get sanction to prosecute these people. That's the problem. Still, you want on Monday, then I'll give you. Don't be dissatisfied on that. If you want to satisfy me, I'll put it on Monday. 3:30?
Yes.
3:30 Monday.
Yes.
3:30 Monday. You will argue your part. Yes. 3:30 Monday. And you ask a jury to give the relevant paragraph and give the judgment. I'll give
a short note.
Yes. Short note.
2023 129 was here. L241.
If you can get some contrary judgment, you definitely do. I don't think you can get it. Still, you never know. The judgments are from either side. If you seriously search something, you will get something or the other. Yes.
Item 40.
Well, the entry border till there.
Entry border. Monday 3:30 till 3:30. Yes.
Yes,
madam.
Item of 40 minutes.
Yes.
My lordship, I have claim for the crossing of the affair, my lordship, and it's my personal case, my lordship. My lordship, the fact is that property is mine. I am in the house. Outsiders came, house trespassed. I lost affair in the police station. Again, counter case has been lost against me that they have lost the case, my lordship.
Yes.
So the investigation has been completed.
Last time taken time for the investigation report, my lordship.
Have you served the opposite party number 2?
Opposite party number.
How are you related to opposite party number 2?
Opposite party number 2 is my lordship. He is the
Mahendra Kumar Sahu.
IEC.
The investigation of this case is.
Sorry. Savita Kumar Kumari Panigre. And 3 and 4. Sumitra Behra.
3 is the IO, my lordship. Who was
Achha, 3 is also. Okay. 4 then. Sumitra Behra.
complainant.
How are you related to Sumitra Behra?
She is telling that I am the relative of my father because after death of my father, they against his husband, 1302 case has been lodged in Chhatrapur police station, and her husband and other 3 accused, they have been not arrested, my lordship. For that only, they as they are not arrested, they tried to grab the property by illegal. Fully they have entered inside the house, and on the spot.
You are not related to Sumitra Behra.
No, my lordship. On the spot only, I called emergency PCR van, everything, and everything has happened in presence of police only. Nothing is unknown to the police, but intentionally, my lordship, it has been done because the SP of Barampur, before death of my father, my lordship, the house was given on rent. And the tenants they were not paying the charges, my lordship, the house rent, my lordship. That I have first have affair in the police station, and they SP sir assured me that you come one day and we will fix a date and you will pay. They will pay your rent charges and they will go. On which date they have fixed, my lordship? When I met the SP, on that day already they have vacated the house. And they have not given a single money. 3 to 4 months they have taken the money or whatever else the police has kept, or I don't know. But they have already vacated and the house was open, my lordship. SP told that you just go to your house and your house is vacated.
Yes.
Then when I reached my house, I was around 10 to 15 minutes. After the 10-15 minutes, I was in the house only. 4 to 5 persons came inside the house and forcefully they have trespassed inside the house. That we are the owner and we will stay in the house. This is the allegation they are saying, my lordship. And after that, I called to the SP also, IEC, IO, all. And they have come to the spot also. The person who was
now in possession of that house.
They are in possession, my lordship. Forcefully. ROR is in my name. I have annexed the ROR also, my lordship. Annexed
This
to
is
my
self-record property of your father.
My lords.
Yes.
Annexed to my lords.
Mr. Rahul, what is the position? Investigation.
Now till in perhaps no, charge sheet has not been submitted.
The police is playing a big thing here.
Sorry, that it is a bias mistake.
This requires my lord.
My lord,
The instance of SP, all this thing happened.
on 7/4/2022, my lord, the IO my lord given a letter to this office, my lord, stating that the investigation made there is prima facie evidence against the petitioner for the offense under 294 being testified by the appearing witnesses in a cogent manner. The investigation of the case is in progress pending agents of the petitioner. Pending agents of the petitioner. 2022. Petitioner and other follow-up legal steps awaiting further instruction from the honorable court passed in the IO number 1565/2021. 1565/21.
What is this I? Was there in direction?
1565/2012.
That is some order.
Not your as the petitioner.
That is they have not completed the investigation.
You are doing the case which has been filed against you.
This is the detailed copy of the Bharatpur police station, my lordship. I have lost the case and the case is against me, my lordship.
No, the case which has been filed against you, in that case, are you on bail?
My lordship.
You have got bail in that case.
In the IE, my lordship.
You got
In the High Court, interim protection only that. My lordship.
The investigation of the case is progress pending exams of the petitioner and other follow-up action legal steps awaiting the instruction from honorable court. Passed no.
No, where is no courtship order?
1565/2021.
There is nothing in the record. Nothing. I don't find.
But that has been written.
Interim measure is directed. There, no courtship action shall be taken against the petitioner. Inevitable. The no courtship action is not. The investigation is not stayed.
Since the 294 file is there, they wanted to examine the petitioner, my lord. I didn't submit
Have they called you?
No, my lords.
They called the investigation of the case progress pending exams of the petitioner.
Show me whether you have given any notice to her.
That is my lord. That is on 2022.
That's right. This order was passed in 2021.
My lord.
1/12/2021. No courtship
My
action.
report sent to the office on 17/4/22, my lord. This report is instruction report, my lord.
But this order doesn't stop you investigation.
Some judge, my lord.
Yes, then.
Instruction whether they have some judge.
My lordship, it's a mastermind of everything is SP, my lordship.
That SP might have gone and long way that SP was he might have gone somewhere else. He might have gone now.
It's there. In Bhubaneswar DCP, Pinak Mishra.
But you don't tell the, he might have gone. Fresh instruction. Get fresh instruction. Interim order is already there.
What is there, my lordship? I want to tell unofficial thing, my lordship. The IO, when she came for the taking 161 statement, my lordship, she said that the property which you are relating and SP is interested in that property. So, and what money you tell, sir will take. When I didn't agree, they are intentionally to harass me. All these things they are doing, my lord.
Don't go by these things. No SP will purchase the disputed property.
I will not sell, my lordship, but only to harass me, only they are doing all this.
Maybe, but I'll ask for a fresh status report. And if the police send you the notice, you please go and cooperate so that it will reach a logical conclusion.
Change in the meantime, my lord.
Yes. Fresh report.
Another thing that which my affair was lost, my lordship, I want to know the status of that also. So
That is not subject matter. The entire status report in both the cases you try to get.
That is my
Both the cases and cross case also. Okay.
case completed.
Entry got to continue. Okay.
my lordship.
Yes.
42.
Oh, please.
Yes.
Here, order taking convenience.
Yes.
Past and in state, taking convenience of the offenses. Punishable conditions, these are very specific and other elements. And we kindly see the order. And page 27.
27.
Because it's continuing to order, ultimately, order dated 26/12/2022.
Yes. Yes.
The case record is posted today, produce the protest petition.
376. 448. Yes.
The big player was the case is. And a citizen for minor, old man of 70 years. Time and again, the victim has lost initiated number of cases against the petitioner, and in almost all cases, petitioner has been, final report has been submitted by the investigating officer stating that the case is all false. But I might be see case 4, paragraph 7.
Yes. Yes, there is a chart. 7 cases.
I have given the chart where this informant is Tulona Mahakur.
All 376 also earlier.
Yes.
323, 376. Why are you after this old man? You need
Again, my lord, again, after
this is 8th case.
after my lord, in this case, also final report was submitted.
Then all these cases, false, trial going on, false, 1, 2, 3, 4.
The charge has already been taken. I'm coming to that. I have stated so. I have not sufficient.
See, 7 cases she has filed against this man. Out of that, 6 cases turn out to be false. 1 case trial is going on. And this is the 8th case. 376. This man is 70-year-old man. You see, 70 years. But he is up to the C45.
And husband and wife both are judging me by anything.
If that is so, my lord, I am submitting one thing. Only to uplift this case and only to give a threaten to drop down this case, again another FIR was lodged and her whole.
How many cases registered against you by him?
Two cases.
In the year,
2 cases.
let me go. I have stated in paragraph 9 mechanism. The genesis of these false cases in one is one affair number 58 of 2013, lost by the brother of the present petitioner against the informant in the present case and our husband and her son for offences punishable under section 4.
What happened to that case?
That case has been is pending and charge sheet has been submitted against them. Thereafter, the informant along with her husband has.
That is 2013.
By 13, and you will see the chart. First case is 2013.
13, 17, 17.
Thereafter, the informant along with her husband has been filing false cases in order to harass the case. After that.
Why don't you settle it?
Allow me to submit something.
Of course.
Saying something which I cannot say that case in privacy, my case is made out, and 376 is there, so. But here is a case. I am drawing my attention to the latest judgment on this point, this code. The law of the subject is AR 92 Supreme Court 604, where the court can interfere. Beginning from AR 60 Supreme Court 866, the couple's case,
R.K.
Kapoor's. And till date, the law is court is to see a privacy case, court is not go to the merits and demerits. But while deciding the mother-in-law's case in 1992 Supreme Court 604, they have fixed up 7 criteria. One of the criteria in that judgment is
Marital prosecution.
If the prosecution is coming with a case for wrecking despite his personal grudge.
Yes, that is why I looked at the chart and.
That part has been taken note of by the judgment of Hon'Ble Apex Court by this paragraph 30.
Yes. Yes.
I draw better the
The multiple FIRs have been registered over the period of time, and in the background circumstances, the registration of multiple FIR assumes importance, thereby
attracting the issue of waking when and the yes, that is one of the
Ground number 7.
yes.
And this.
Yes, I understood you. Yes, what do you say?
Lordship, admittedly, there are civil dispute and criminal dispute between the parties since long. Civil cases are also pending before the subordinate courts. Thereafter, criminal proceedings have been filed. Some cases have been turned out to be a false. Cases have been dropped. In 3 cases, charges have been framed. Trial is going on. In 2 cases, trial has already been started. Witnesses were examined. In the present case, my lord. In the present
one case, except this case, another case. All other cases are
in the present case. It is a case of 376-448. In the present case, after recording of 164 statement of the victim, FRT has been submitted.
In that
164
has been taken note of by Honorable. I was quite conscious by that may be the submission of my learned friend. But in the
in that case, 164 statement is filed.
Just let me allow me to comment.
2017, 113, SCC page 369. And I'm just reading the relevant paragraph, what my learned friend is drawing. The appeal was filed against the enforcement judgment of the High Court by the accused, containing that there was sufficient material collected in the investigation which proved that the allegations were unfounded and the prosecution of the appellant was an abuse of the process of court. In para 23, this court noted several circumstances on the basis of which this court held judicial conscience of the High Court to have been persuaded it to pass the criminal proceedings. This court further noticed that the investigating officer has acknowledged that he could not find any proof to substantiate the charges. The charge sheet had been filed only on the basis of the statement of the victim, proceedings under 164 CrPC. In para 24 and 25 of the judgment in Pathan of this case, that is 2013 Supreme Court, I have also brought. Again, my lord, Honorable Apex Court was pleased to observe in paragraph 51. Inherent power given to the High Court under section 482 CrPC is with the purpose and object of advancement of justice. In case solemn process of court is thought to be abused by person with some oblique motive, the court has to thwart them.
That I would just want to know what is the motive.
Yes.
What is the motive by the way? What do you want? Let us come to the real point.
I am coming to the real point.
See, if you have filed couple of false cases, he might have filed couple of false cases. What is the rule? What do you want?
It does not give him a right to enter somebody's house and rape a lady.
Property issue or something else?
Property issues are there. And thereafter they have set fire.
Whose property? Who is occupying?
That Dhaniram Maji has occupied the property of the informant.
What are the suits pending?
The 3 suits are pending before the that is senior civil judge Karanja. 3 suits.
Suit for declarations?
Yes. Suit for declaration and also another suit is for that partition.
He is related to you?
No, he is not related to me. He is a villager, but in a partition suit, he has interfered in that Dhamrama.
He is in possession of property. Have you filed order 39 rule 1 and 2?
Yes.
What happened there?
I have got the order. Thereafter, when I have already given a fence to my area, again with the villager, with the help of the villager, he has tried to be thrown out from the village. They have again tried that I should drop this case.
You tell me one thing, will you go for mediation and all?
No, madam, because her house has been completely burnt. Another FIR has been filed. It was lodged under section 436 recently.
It's a never-ending process. It's only for property, filing false cases against each other. And using judicial process like this.
Has been taken note of.
Why don't you settle the dispute?
I got a ঘর পড়িলা পর কোন সেটেল করিবে তে
ঘর পড়িলা
আগে রেপ হেলা পর ঘর পড়িছি লজিক মে কাইন্ড পেরো দি 164 স্টেটমেন্ট
যে সেই 164 টা আমি দেখছি এটা বলবে প্যারাগ্রাফ প্যারাগ্রাফ 40.3
164 লজিক মে কাইন্ড পেরো দি 164
দেখি
तेईस जाएगा टिक्के देखिए
case of rape, definitely 376 rate of permissive. Most importantly, as against the aforesaid allegations, no pleadings whatsoever have been filed by the complainant, and even during that last week, the charge sheet has been filed only on the basis of the statement of the complainant pursuant to section 164 CrPC. Based on the holistic consideration of the facts, circumstances summarized in the following two paragraphs, we are satisfied that all the states delineated by this court in Rajit Thappar's case stand satisfied. All the states can only be answered in the affirmative. We therefore have no hesitation.
Even charge these costs. 164 statement was there. FIR after charge sheet is filed, charge is framed. Then also the court says that it is out of a vengeance, it can be cost.
Lordship kindly peruse the moment put the 164.
Part and I'll put it. Part and one. I've heard you. You give a noting and you will argue on that. You come with all this. And still keep it open in your mind and ask your time. If you want to go for
the situation is, my lord, one thing I am submitting, when an FIR has been registered under section 436 and the accused are getting the benefit of 41A CrPC, that is strange.
Then you have
CRLMP before this honorable court and it was pending.
Against 41A.
Yes. Investigation was not at all taken in a proper manner.
You have a grievance against police also then.
आजा फायर रिपोर्ट अछि दमकल आस्तिले घर माने निया लागि जाईछि सब जिंस हेछि.
The problem is you have filed many cases and all the cases turn out to be false cases.
That does not give that this case was also a false.
Maybe looking into your history, the police might have thought again.
Admittedly, when there is a
best thing would be you try and settle the dispute instead of fighting it out. And that you can give a try because see, so many cases are there. And he is apparently subject to what you are going to say. Apparently, he is covered by the 7 clause 7 of
Bhajanlar's case.
Bhajanlar's
case. Bhajanlar's case.
That's one of the provocative view. I'm not saying that.
My lord, but these cases, all the cases are of different facts and different situations, my lord. It has to be decided in a.
You will argue that.
Perspective.
You will definitely argue that. I will give you the opportunity.
And since already.
What's High Court of Orissa notes?
40? 43. 14. You come with full preparation with the judgment and all. I have heard him.
Last item 45.
Wherever the entry order is there, you continue.
Item 55 lordship. After lordship.
If you argue, I'll come.
Once I have item 51 notes. Lordship admitment 5. Item
from this side, let us see. From this side, I'll come. 85.
Interview there. Interview there. If no interview, then it will not continue. If there is no interview, it will never continue. How will it continue? If there is it will continue.
Last letter specifically, lordship, I mentioned before lordship. Lordship can remember I was in DC because I was not well.
I don't remember.
Lordship extend the interview order. What are the
why you see the posting?
Lordship, my
at 2 o'clock then you come.
Lordship,
opposing I can't help you.
Today I have some personal difficulty, lordship. That's why lordship,
then I am not saying anything.
Lordship,
I am not taking up the matter. Then what I will not take you up. Yes.
There is no interim order.
Yes, 51 feet. Yes.
Yes, no.
I have entry order.
Yes.
Item 34.
Yes, sir.
My friend is there.
Entry model.
59 lots.
And then you mentally prepare that after lunch. All the matters, wherever the entry model is there, continue and adjourn.
Let's 4 days on this. So.
Thank you.